We now invite you to sit back, relax, and enjoy today's presentation. It is my pleasure to introduce your host for today, Katie Bien, Director of Business Development for Jones, Skelton Hochuli. Katie, you now have the floor.
Thank you, Kara, and welcome again to our webinar today. We are pleased to have you with us as we roll out our new webinar program. Today's webinar is the first in what's going to become a regular webinar series. During these sessions, you will see different attorneys focusing on different areas of the law. Some of these webinars will be general in nature, while some will be more industry specific. If you have a suggestion for a future webinar, please feel free to share those ideas with us. This session is being recorded and will be available online. Within 48 hours, you will receive a link to this recording via email, as well as a brief survey. We appreciate your feedback and encourage you to please take a couple of minutes to complete the survey. Now, I'd like to take a moment to introduce our presenters. Mike Halvorson has been practicing for over 13 years in trucking and transportation defense, including commercial cargo and property law. He also handles personal injury, dram shop, motor vehicle, and premises liability defense, and has mediated, arbitrated, and tried a wide variety of these cases. He currently serves on the Trucking Law Steering Committee for the Defense Research Institute and co-chairs the firm's Transportation, Auto Products, and General Liability Practice Group. Joining Mike is Don Myles, who has been representing clients in the areas of insurance coverage, bad faith, and professional liability for over 30 years. Don has tried cases involving insurance bad faith and professional liability, many also involving punitive damage claims. Don has held senior board positions in a variety of organizations, including the Federation of Insurance and Corporate Counsel and the U.S. Law Network. Don and Mike both frequently present and publish articles on litigation-related issues, and we're happy to have them with us today. Now, without any further delay, let me go ahead and turn this over to Don.
Katie, thank you. And for everyone out there, welcome to the JSH. This is our first webinar. And along with Mike, we're going to spend the next 30 to 35 minutes talking about the perfect claim file. And then we'll be able to field some questions thereafter as time allows, up to about 45 minutes. What I'd like to talk about first is when I go to any seminar, the first thing I'm thinking about as I'm sitting out there is, so what and who cares? Why should you care about the situation of a perfect claim file under the circumstances? All carriers owe the duty of good faith and fair dealing, and what that requires ultimately is that under the circumstances, your file reflect that fairness and fair dealing. That in your file should reflect not only things that are favorable to you, the carrier, but also to your customer, the insured. There's a lot of money spent by the various carriers on commercials talking about the type of coverage that's available and what's going to be done to help your insured under the circumstances. You're in good hands with Allstate. Like a good neighbor, State Farm is there. The marketing department spends that money, and then you're on the customer service end of it just like we are. And it's important that your file reflect that under the circumstances. Since we are in the customer service industry, also, those files need to reflect the story of the claim. Someone should be able to pick up that claim file under the circumstances, not having read it, and have a pretty good idea of what was done, what happened, and ultimately whether it's a claim that should be honored and paid under the circumstances. You didn't need to advance the... Is it a fact or is it a hunch? We have objective data and subjective opinions. The objective data is the things of where, what, who, why. Those are the things that belong in the claims file. We need to put those in there. The subjective opinions are things that we really don't want in the claims file. One of the reasons is I've seen circumstances where I pick up a file, a bad faith file, for example, and we have the opinions changing constantly. Based upon the initial investigation, you may come to the conclusion this is not covered. You may then speak with the insurer and say, wait, now I've changed my mind. I think it might be covered. You speak with a neighbor and do further investigation. No, I changed my mind again, it's not covered. You're going to wind up looking schizophrenic under the circumstances if, in fact, you set forth all your subjective opinions in that claims file. The way you really want to handle it is put the objective data in the claims file and make your final determination and then include it within the claim. Number two, the availability of information that rises to an evidentiary level. This is what we like to refer to sometimes as hearsay. Everyone knows what that is, and under the circumstances, we get a lot of it when we investigate a claim. I love firefighters, the first responders. But if you're handling a fire claim, for instance, I would say 50% of all fires, the firefighter, someone will walk up to you and tell you if you're investigating, it looks suspicious. What does that mean? Ultimately, if the firefighter's deposed, they'll tell you that what they meant was they don't know what caused it. If you write it in the claims file and your opinion is the insured might be involved, that's something very different. And you want to save those types of opinions until your investigation is complete under the circumstances. The balance of information. You're supposed to include in all those claims files not just what is favorable to the carrier, which may be relied upon as part of your investigation to deny a claim or not pay as much on a claim, but also to balance that information that is favorable to the insured under the circumstances. Ultimately, if you wind up sitting next to Mike or I someday and your deposition is taken in a bad faith case, you'll be asked the question, do you understand the duty of good faith and fair dealing? We'll have coached you well enough to say, you'll be able to say, yes, I do. And they will ask you what in your claims file reflects that balance that is owed and what is beneficial to the insured. Along those lines, if any of you have a highlighter and you highlight your file, I will bet that you've highlighted only those portions of your file that support a denial. When the original file is requested, which many times it is, what is your file going to show? And how will you explain that what you highlighted was only that information that benefits the company? Avoid rose-colored glasses or over-relying on a single piece of evidence. Many times this happens, particularly in fire losses or other fraud-type losses. You find one witness, you find one piece of evidence, and that really tips the scale on a denial of coverage. Avoid doing that, and remember, ultimately, if someone sees the entire file, you're going to need to defend your opinion. Consider an independent opinion or advice of counsel. Many times when there's been a reservation of rights or there's an issue regarding coverage, the carrier will consider retaining counsel. The most important part is if you do retain counsel, get a good lawyer whose opinion you ultimately trust and will follow. There's been instances of cases reported where a carrier's gone out and obtained one legal opinion, which they did not like, so they got a second one, which they did not like, only to get a third, which they did not like, to get a fourth, which they liked, which would have been perfect, except in the bad faith case, all of the opinions were discoverable. And it didn't look too good. It was shopping for a legal opinion. So again, that can be problematic. The quest for the perfect file. Imperfect decision-making does not equal bad faith. To answer the question posed by the title of the seminar, there is no such thing as a perfect file. But what you're really striving for is a reasonable file which you can defend, that you gave equal consideration, and regardless of the ultimate conclusion, it was fair. So imperfect decision-making does not equal bad faith. Be engaged in the claim. Take affirmative action to manage the file. We all have files, you and I, all of us, that we don't like. We don't like the public adjuster. We don't like the lawyer. We don't like the insured. Under those circumstances, if you're like me, what happens many times is you come in on a Monday morning and you see that file in the corner of your desk and you say, I'm not going to start my week off with that file. I'll do it this afternoon. You then go to lunch and come back and you see that same file and you say, oh, you know what? I'll do it tomorrow when I can get a fresh start. That's called delay. And ultimately, it's that file that all of us have that we don't like to pick up and handle that's the one that turns into the problem, bad faith lawsuit. So all of you sitting there right now have files just like I do, and you can think of them right now. When this is over, remember this. That is the file you should pay the most attention to. You're not alone. Use the resources available to you. As I tell some of the younger lawyers here, you don't get enough money, paid enough money, to make some of those decisions. Go ask someone else. So that ultimately, if you deny a claim or reserve rights or you make an offer that someone's not happy with, you can say, I spoke with others, a supervisor, and they agreed with it. It's a good resource and protection for you, quite candidly. Understand the needs and motivations of the policyholder and the claimant. A lot of times it's the tone of voice, the way someone is treated, that will go a long way of dealing with an otherwise difficult situation. And keep in mind, the marketing department has made a lot of promises on TV about how, indeed, these insureds, your customers, will be treated. So keep that in mind.
When we're talking about what the specifics of a claim file should have, every state has some type of rules in place that claims handlers, adjusters are required to follow. These rules are in place to basically ensure that the insureds are being treated fairly, that the third parties are being treated fairly, and that you're complying with the requirements set forth in the insurance contract. In Arizona, that statute is called the Unfair Claims Settlement Practices Act. It's important that as you handle these claims in a particular state that you're familiar with the rules of that particular state so you know what type of material and documentation you should have in your files to show that you are in compliance with that particular statute. In Arizona, the statute that we're dealing with really is looking at general practices. Are these things happening with such frequency that we consider this a general business practice? And generally what they're looking at is whether the adjusters are failing to act reasonably and promptly on communication. Are they refusing to pay claims without some type of reasonable investigation? Are they failing to make decisions within a reasonable time? Are they not attempting to reach settlement where liability is clear? And whether they're giving proper and reasonable explanations for denying or failing to settle. In terms of the specifics of what they're looking for in a claim file, let's talk about the most basics. When we receive a claim as claims adjusters, we are required under Arizona law to acknowledge receipt of the claim within 10 working days. That should be in writing, and it should indicate that you are in receipt and that you are beginning an investigation. The claimant or his attorney will often send correspondence to you, emails to you, phone calls. You should be documenting your file that you're responding to that, to everything that needs to be responded within 10 days as well. Most claims are small. Most claims can be handled within a short period of time. Our Department of Insurance has promulgated a regulation that indicates that 30 days is a reasonable amount of time to handle most investigations and complete a claim. Of course, many claims cannot be completed within 30 days. In those situations, you have basically 45 days that you need to let the insured know, or the third-party attorney that is breaking the claim on behalf of an injured party know that we have not gotten the information requested. For example, the police report has not yet been prepared. We are still missing medical records. We're still waiting for opinions from experts or public adjusters. Whatever the reason is, those need to be documented. Not only what you're still waiting for, what you still need, but if there's reasons that you cannot accept a claim at that particular time, those reasons should be documented as well. Some of these claims last for quite some time. If we have a patient that's still treating, has major injuries, we might not be able to settle that claim for a year, year and a half. It's still important that you're going to that file and following up every 45 days, excuse me. And if you don't do that, and if you ignored that file, you could have some liability under the Unfair Settlement Practices Act, especially if they show that is a company-wide policy. Also, when you're dealing with unrepresented parties, either in a first party, your insured, your homeowner, your UIM, your UM, insured, you have, if you're in active negotiations with them, you have 30 days before the statute of limitations to tell them that the statute of limitations for them to sue you, essentially, is going to pass. Likewise, if you're dealing with an unrepresented third party, the person that was injured in the auto accident, if you have been in negotiations with them and perhaps you haven't spoken to them in 6 months, but there has been negotiations and you've been every 45 days telling them this is what we need, this is what we're still doing. In that situation, you're within 60 days of that statute of limitations expiring. You need to send them a letter to advise them that the statute of limitations is expiring. It's important to note that the Unfair Claims Settlement Practices Act does not create a private cause of action. So in other words, that third party cannot sue you directly under this act. Instead, these are regulations promulgated by our Department of Insurance. And you can be subject to fines and other civil penalties for not complying with the statute, but you can't be sued independently by other parties. That being said, there is nothing to prevent the other side's expert in a bad faith lawsuit to suggest that these things that are contained within the Act and the regulations are what's called the standard of care. So if you're in violation of these type of rules, they are going to make arguments that you're in violation of the standard of care and that you should be held accountable for it.
Communication. What to write in a file. Keep the file documented contemporaneously. Now, that may seem obvious, but there's been instances where people, after they're involved in a lawsuit and the file has to be produced, they go back and make entries either in the electronic file or in a hard file to the extent that it might exist. That becomes very problematic because then it looks like you made up facts. So it's important you do it at the time something happens. We've already talked about objective facts only. Do not include opinion and subjectivity in there, and accurately reflect what was said and what occurred. All of your claims manuals require that you include within the claims file those things of substantial interest or that are important to the handling of the claim. If anyone said anything that's important, it should be documented, because if you have an important conversation you testify to later and it's important enough that it should have been included in the claim file and is not, they're going to have a difficult time believing that you actually said it.
Well, Don has expressed that you should not be putting opinions and subjectivity into the claim file, particularly as the claim is being adjusted throughout until you come to a final conclusion. You still need to put the rationale for your decisions in it. For example, why do you need the documents that you're requesting? Why is that important for you to complete your investigation? Why do you need to take that examination under oath? Why do you need the particular experts to give you opinions before you're able to reach an ultimate decision? These are questions that may be asked of you later, and if they're in your file, you can go back and refresh your memory as to what you were trying to do and accomplish in your handling of that file. Likewise, many adjusters handle claims for multiple companies. They're under one umbrella that has multiple arms. And it's important that when you're handling for a particular arm, that you're corresponding on behalf of that particular arm. You're not using the wrong name of the company because you're handling three and you're just too busy to use a proper name. It looks sloppy and it'll come back to bite you. Also, as Don indicated before, if you're eventually involved in a litigation to explain the contents of your file, you need to understand that the contents of your file is discoverable, meaning the claim file, but more than that, the emails, the diary notes, all the correspondence, all of it is going to someday be put in front of you, and they're going to ask you, why did you write this? So when you're preparing the file, do so with the expectation that that communication will be read to a jury, and you're going to need to explain it at some point.
You know, Mike, just to follow up on that, I will say that you might as well, in that difficult file that we talked about earlier, start all your notes out with, "Dear jury, here's why I did this," because it will be discoverable, and they will scrutinize what you said and how you said it. Unreasonable investigation allegations. A lot of times, particularly in the UM and UIM cases, you see this failure to obtain all the physician's records. Sometimes the investigation is conducted so that we get only those records that support our conclusion. That becomes problematic. You should be aware of it and get all the records. Failure to speak with the primary treating physician when applicable, and failure to call a treating doctor. A lot of times you'll have instances where perhaps the insured treated with a chiropractor. You may have an IME done, or initially they treated with an orthopedic surgeon, and they differ on what their recommendations are. It can become very important that you picked up the phone, even if you don't speak with the physician, that you made the attempt and you document that under the circumstances. Because ultimately, if you rely on the orthopedic surgeon without speaking to the chiropractor, someone will ask you, why did you rely on the ortho and not the chiropractor? What was it other than the designation and their opinions were favorable to you? So that can be important also.
We keep talking about the type of communication that should be documented, and a lot of it's dealing with opposing sides, experts, those type of thing. But you must keep in mind that you also need to be in constant communication with your actual insured. A lot of times first notice of claim that we have suggests that it's a soft tissue injury. And we got a $50,000 policy. The claim might be worth $10,000. We'll handle it and we'll move forward. Well, 6 months down the road, we find out that there might be a fusion or there might be a torn rotator cuff, whatever the issue. Well, now we got some concerns that there's some excess exposure. At that point, you definitely better be in communication with your insured. Letters should be going out to your insured to explain the situation and why there may be problems that could cause some excess exposure over his policy limits, and then invite him to retain his own counsel for advice on how to properly protect those assets if he feels it's necessary. Likewise, as Don indicated earlier, selecting specific medical records that support your arguments but ignoring other medical records isn't the way to handle claims. We often have an expert that we'll hire that is somebody that we know to be conservative, somebody that we paid, that we like his opinions, and that's what we rely on. But we ignore the 6 treating doctors that give opposite opinions. When you do that, you're not properly evaluating the claim in terms of an equal and a reasonable concept in terms of evaluating for the insured as well as yourself. Claims handling caseload, I'll let you see this a lot more than I do.
Well, it's just interesting. I'm sure everyone is overworked and has more claims that they can handle. Please don't write that down in the file, because we've seen people do it in the past. That's an allegation that's frequently made, that when something is missed or not done, that the claims handler's caseload is too large. So just suffice that may be true, and it probably is, but please don't write it in the claims file. What not to write? These are some of my favorite. Supervisors out there. If you're a supervisor, please do not write in the claims file the criticisms of how the file was handled. The particular supervisor who wrote this note, "This is the worst investigation I have ever seen," had 35 years experience. By the time plaintiff's counsel was done, he had established that this supervisor had looked at over 30,000 files over the course of his career and got him to say, of the 30,000, this was the worst. Now, it was difficult for him to get out of that later. So please don't write that in a claim file. This file is a mess. It might be, fix it. Don't write it in the claim file if you're a supervisor. The insured is too dumb to have lied. If we drag this out a little longer, they may accept less. The problem with that is most of the general public believes that's really what we do. So dragging it out is not something you want to include in the claim file. Lastly, we need a little more information before we can deny this claim. The investigation needs to be done with fairness, equal consideration. And if the attitude is, we're just going to find information that supports our conclusion, that alone may be bad faith.
You might have a claim that comes across your desk that smells a little funny. For example, there's a stolen car or a house burnt down. And you might have some just gut feeling that maybe something else is going on here. And you write into your file, hopefully the police will arrest the insured before we need to pay this claim. Not a good idea. You are bound to, by the rules and the case law of the state you operate in, to perform an independent investigation, and you're expected to perform it reasonably and fairly. By saying something like this, that shows you're doing the exact opposite. You're relying on somebody else, and you're delaying your investigation by hoping the police is going to arrest them and prove the case for you. The insured has made so many claims, this one is specific. Again, the fact that this insured may have several claims pending or have several in the past, that doesn't excuse you from still performing an independent, reasonable investigation with particular regards to that claim. Ask Mr. X to assist us with the investigation. He'll get us what we want. Again, whether or not that's true, that's something you definitely do not want to put into a claims file. Using the same expert on every single type of claim because you know that you're going to get that opinion is trouble. Documenting that's the reason you're doing it is even worse.
Yeah, I think it's important, Mike, sometimes to just mix it around and use different people in different circumstances to get rid of that allegation that will be made ultimately.
The other problem that we see, and it's very typical in Arizona, especially within the last 5 years or so because of our developing case law, it's the threat of a policy limits demand. They will give you, you will get a letter in the mail, and it may be the very first letter you see from a plaintiff's counsel. And it will say, here's some medical records, here are the facts of the accident. We hereby demand you pay your entire policy limits within the next 10 or 15 days. And at that point, that's your first notice of claim. You have done absolutely no investigation. We see those all the time, and it's a setup letter because if you fail to pay that policy limit and at some future point the insured gets hit for something in excess of that policy limit, they're going to come to you for that excess verdict. So you need to obviously perform your investigation as timely as possible, knowing that these type of letters are coming your way. And the letters we're talking about, you're going to see language like, this case clearly exceeds your policy limit. You're not protecting your insured by failing to pay the limit now. The classic one is you need to pay your policy limits with something else. For example, we need an affidavit of financial insolvency from your insured. Well, in that situation, you may have already decided to pay your policy limits. But because you didn't submit an affidavit of your insured saying we have no other insurance or we have no other assets to collect, they're going to consider that a denial or a rejection of the settlement demand. So when you do get these letters, make sure you look at all the requirements and that you fulfill all the requirements, unless, of course, you don't feel reasonably that it's worth the limits in that particular case.
Just to continue on with what Mike said is sending you nasty letters. Sometimes they will send you a letter every other day. It's important, particularly in those circumstances, that you respond to them, nicely, that you don't use the same tone that they used. Their actions will be excused, yours will not. That's just reality. They'll threaten to report you and the company to the DOI and Department of Insurance to see if they can get them involved. They'll send a letter to your insured sometimes saying that, look, your company's not treating you fairly and they're not paying the policy limits. They'll file a lawsuit. They won't even give you a copy to see if they can get a default. They'll request a Morris or Damron agreement. This seminar is certainly beyond explaining those two issues. Suffice to say, if you see those two words, elevate it to someone immediately because you have a dangerous situation on your hands.
Always remember when you're getting these policy limits or time limit demands that you need to let the insureds know that you just received that demand, that you're performing an investigation, and that they have the right to retain personal counsel at their own expense because there is a risk of excess exposure. And again, when you are responding to these demands, you need to make sure that correspondence, obviously in writing, but that you're detailing exactly what you're accepting. Here are the documents you requested. Here's the information you requested I provide, and yes, we are accepting that demand.
Victory defined. Ultimately, a resolution on the case or the claim on terms acceptable to both the insured and the carrier is what you're looking for, a consensus result. That's pretty much the result in a mediation, where both parties walk away saying, look, I didn't get everything, but it was fair under the circumstances. Be effective, not right, and don't lose your objectivity. You're not out there to prove anyone else wrong. This isn't personal. You're a claims professional. This is your job, and ultimately, this is the business that you're in. No surprises. All of our clients tell us one thing. They do not want to see surprises. They don't want us to get up at the time of trial and change our evaluation because we didn't evaluate it properly under the circumstances. Likewise, your superiors don't like surprises either, finding out that there's a stipulated judgment for several $1 million where there was a policy limit of $100,000. Keep your management informed too, and your life will go a lot smoother. Now, to end this, we're going to talk about the top 10 list of the worst bad faith trial documents I think we've ever seen. Mike, number 10, this is the worst investigative workup I have ever seen us do.
Number 9, our policy language is ambiguous, but I think it allows us to deny the claim.
Number 8, this guy is illegal. If we set his deposition, it may scare him back to Mexico. And just to reiterate on this a little bit so there's no confusion, this is an insurance contract we're dealing with most of the time, and the fact that someone may be here legally or illegally is completely irrelevant to your investigation. They should be treated exactly the same under the circumstances.
Likewise, we keep talking about delay. This is a bad sentence to put in. If we drag this out a little longer, I think they will go away.
Number 6, let's ask them for more information before we deny the claim.
Number 5, The employer hates this employee and says he's lying through his teeth, so let's deny compensating.
Compensability, there you go, Mike.
Sorry, two different things.
Send this to Dr. X to review so he can get us what we need. IMEs, again, be very careful about who you use and why you use them under the circumstances.
Number 3, I am too busy to contact the doctors tonight and see what the insured comes back with.
Number 2, I can't find any proof this guy is a fraud.
Number 1, this subscriber is an... You deleted that out, didn't you?
It's actually, the word is asshole, and let's deny it. That was actually in a claims file, and the case went to trial. You can imagine how they blew this up and talked about it over and over again. We actually did some jury research on it and made the decision to go ahead and embrace it. We said, ladies and gentlemen, we apologize. This should not have been in a claim file. But after you hear all the evidence, we're convinced that you'll agree with this. Now, it was a great case to try. It was a lot of fun. But I really don't recommend it. You put it in a file. Questions and answers. So a lot of you have sent in questions. We're not going to have time to answer all of them, but we're going to go ahead and take a few and go ahead and read them. I'll take the first one, Mike, if that's okay.
Sure. Okay. Over the years, I have heard, quote, write everything and, quote, nothing down, depending on the speaker. Which is it?
Well, it's interesting. About 30 years ago, when I first started practicing, we told everyone, and I was told, write everything in the file. Later, when some executives got deposed and their files were torn apart, they told everyone, the claims staff, don't write anything down. Now we're back to write everything that's important down. So I think the takeaway from that, Mike, is although it sounds good sometimes, they can't get cross-examined on your file. The thing really to do under the circumstances is write down what's appropriate. Next question.
You know, we have one come in here. Mike, I think you can address this one as it pertains to one of the slides we had earlier. Does this act apply to health insurance claims as well as typical commercial insurance coverages?
Yes, so the answer is yes. Anytime you're dealing with an insurance contract, there is an obligation to handle your insured in good faith and fair dealing. So it applies to all insurance contracts.
One question, what about the use of emails in the claim file? Add them. Well, certainly emails are part of the claim file and they get the electronic file. The problem with emails a lot of times is we tend to treat them more casually, and we really shouldn't. They're just as important as the handwritten notes that you have, so treat them just like anything else in the claim file.
Don, here's an interesting one. It has to do with TPA or third-party adjusters. Question is, are we liable for any problems with their handling the files? The answer is, if you're the insurance company and you're under the umbrella of that insurance company's authority, the answer is yes. The TPA actually in Arizona does not actually owe an independent duty to the insured. That duty is owed by the insurance company. It's considered a non-delegable duty, so any of the actions of the TPA or the independent agency adjusting the claim is imputed to the carrier.
Good point. Another question came in. What these are moving so fast. Can email correspondence serve to meet the requirements of the Practices Act? You have any opinion on that, Mike?
No, I'm not sure I understand.
Yeah, I'm not sure what that one says either.
What about the use of emails in the
I see what I think I understand. The Unfair Claim Settlement Act. Yes, I think that does serve. If you can show that is a two-way communication, it's in writing, I think you can make a clear argument that it does meet the requirements. When you're responding to settlement offers and those type of things, I would definitely want those in letter form so you have both hard copies and maybe perhaps a fax receipt, something along those lines. But in terms of communicating with the insured, if that's the preferred method of communication with the insured, I think that's perfectly acceptable.
One other question, should telephone conversations always be documented with a follow-up letter memorializing the conversation? I think the answer is no. As long as it's in your notes, I think it's fine. So I don't think that's necessary unless it's something very important, perhaps like accepting a settlement offer where you need something that memorializes the conversation. Another question, how should documentation of a person's witness qualifications be handled? That gets really difficult sometimes is if it's the insured and you're the lawyer and your client, the insured, is getting copies of what a bad witness they just made. That comes up quite frequently, and a lot of times we'll put it in the correspondence, but it may not be as harsh as it really occurred. Most of the time I'll pick up the phone, make a phone call and said, look, I said an average witness. What I really meant was a horrible witness. You can put that in your claim file, and you and I understand that, but it's not something I necessarily want my client to read, not because I'm afraid of it. I just don't want to ruin what little confidence he or she may already have. Any other questions?
Yeah, here's one. What are your thoughts on using proper names versus titles? When should a proper name be used, if ever?
I'm not so sure I understand that question.
You know, I wonder if that pertains to witnesses or documenting the file. All right. Let's see, we've got a couple more questions coming in. Thank you. You guys have such great feedback. Okay, so using a name, Joe Smith versus title claims manager, for example.
I don't know what difference that would make.
I don't think it would make any difference at all.
Okay.
Yeah, I can't really comment on that.
Do you have any thoughts on how much information should be contained in the file in terms of quantity? Any cap there?
Well, it's all relative to what type of case and how problematic it is. I mean, 98% of your cases are not really problematic. You know the ones that are a problem. We talked about it earlier. These are probably ones that you need to get back to your desk and take a look at right now that you really don't want to. Those are the ones you need to document a lot more carefully than others. You can't possibly document all of them the same way. Not just the way we don't handle every case the same way. It's different depending on the quality of the lawyer on the other side many times. And in your instances, if you have a public adjuster, you're going to have to work that file harder. That's just the practicality of that situation, and it's a judgment call based upon experience.
Now, Don, talking about documentation, how about telephone conversations? Should they be documented with a follow-up letter to note and document the conversation? I
think we got that one earlier, and I think generally the answer is no. Unless it's a specific document that needs to be sent to follow up and accept a settlement demand, I wouldn't send a follow-up letter constantly unless I had perhaps a public adjuster or someone who was antagonistic towards me that they were not, or they were sending letters afterwards that didn't properly communicate what was discussed in the call.
But Don, you would agree that whatever the substance of that conversation is should be documented adequately within the diary notes or some other portion of the claim file?
Absolutely.
Great.
I think that's about it, Katie.
I think that's great. Thank you very much, you guys. We appreciate your time, and thank you to everyone who's joined us today. If you have any questions that we weren't able to get to or something else that comes up, you can see Mike and Don's contact information there. Please feel free to reach out and send them an email. You can send me an email as well, and I'll be sure to forward that along to them. As a reminder, we did record today's session. We will be sending this out via email as a link. So if you'd like to watch it again or forward it along to some coworkers or someone else you think would find this beneficial, please feel free to do so. Thank you for joining us. We hope you enjoy the webinar, and have a great day.
Thanks.
Thank you.